Why every ERISA disability policyholder or plan participant should be keeping in touch with their attorney during the course of the claim. There are many forms that are filled out in the course of an ERISA disability claim, and so you want to be keeping in contact with your lawyer, particularly when they're asking that you fill out forms called activities of daily living. They're also going to be asking you to have your doctor complete attending physician statement forms, and that's something that your attorney is going to want to control, to monitor, and manage. Now, you should also be calling your lawyer if you are starting to see a new physician, because the attorney wants to get those records, wants to make sure that that doctor is documenting symptoms and functionality and is supportive of your claim. You want to call your attorney if you've been seen in the emergency room for any reason, because obviously something has dramatically changed about your medical condition. And the same holds true if you've been hospitalized. It's important that we are getting these medical records because carriers are going to want these. Now, another reason you should be calling your attorney is if there's been a change in your medical condition. You may have gotten worse and you may have gotten better, and that may impact your ongoing benefits. So the attorney needs to know it and understand it. And of course, if you move, the attorney needs to know because you're going to be getting a new set of doctors, and we want to make sure that, again, these are supportive doctors, doctors who are experts in your medical condition and are willing to support your claim. And of course, if you're thinking about returning to work or you've returned to work, that should be a call that you make immediately. Thinking, preferably not after you've returned to work. Now, if you've returned to work and you've stopped working, that's another situation where you should be calling your attorney. If you get a call or any contact from someone at the carrier or plan that wants to talk with you, an immediate call. You don't talk to them without attorney representation. And if you get some notification that you've been scheduled for a not so nice independent medical evaluation or functional capacity evaluation, you're on the phone right away with your attorney. If you get a notice from the disability carrier that says, too bad, so sad, we're going to deny your claim or terminate your benefits, that's a call to the attorney. You only have 180 days in which to file an appeal, and that has got to be done timely, or you can lose regardless of how disabled you might be. You've got to exhaust your administrative remedies. Now, you should also be calling your attorney if you get any correspondence from the disability carrier or plan that you don't understand. The language that disability carriers use can be gobbledygook. Many times I'm looking at it thinking, what on earth are they saying? And sometimes we actually have to get on the phone with the adjuster and say, what on earth are you talking about here? Did you know this or that? So I want you to keep those things in mind because this is crucial for you to understand and be part of a team. If you have any questions about your rights to ERISA disability benefits, if your claim has been denied or terminated, it's time to call me, 727-894-3188. I can help you get the disability benefits you deserve regardless of where you live in the United States, regardless of the nature of your disabling medical condition or conditions, and regardless of who that disability carrier plan might be. 727-894-3188. Thanks.